Hi everyone, my name is Sasha Hodder. You're on the Hodlcast, and today is Thursday, the 26th of May. And I wanted to talk today about the GDPR, or the also known as the General Data Protection Regulations. These were put forth by the European Union. They took effect actually yesterday on May 25th, 2018. And what it's designed to do is to unify the current data protection privacy laws throughout the European Union, and also to enhance the rights of citizens of the European Union so they can protect their personal information. So the GDPR applies to any business that does either sells or offers products or services to citizens of the European Union, or collects personal information from any citizens of the European Union. So if you're a United States-based company, but you're collecting email addresses from someone in the EU, then you need to update your privacy policy to reflect these new standards. So how do you comply? Well, first you have to figure out if you're a data controller or a data processor. They're defined in Article 4 of the GDPR, and basically, if you're a company and you're selling a product to a consumer, then you're a data controller. If you then hire a third party to come process your data, like as in you're going to hire someone else to send your sales emails and track the analytics on those emails, that person would be the processor. Under the GDPR, the controller is the principal party that's responsible for collecting, managing the consent, offering a privacy policy, permitting access to the website, etc. And if a user wants to revoke their consent, or anything about their personal data, the storage, they would contact the controller. And even if that data is stored on the processor's servers, the controller then has to contact the data processor and request that they remove the revoked data from their servers. So the controller and the processor, before there was no standard for processors, it was only there for the controllers. And it was called the data protection derivative up until yesterday. And I think the reason that they had to put this into place was because the processors were kind of farming out the data, selling it, using it for their own personal profit in some fashion. And so now those processors have standards too. So failure to comply with the technical security requirements here, either by the processor or the controller, it can result in civil penalties. So Article 28.1 states when processing is to be carried out on behalf of the controller shall use only the processors, providing sufficient guarantees to implement appropriate technical and organizational measures in such manner that processing will meet the requirements of this regulation and ensure protection of the rights of the data subject. So data controllers have to seek out data processors that they can trust and that they know are going to adhere to the standards. So now data processors will need some kind of third-party audit to come in and say that they're a trustworthy processor and give some kind of like certificate of authentication or something like that, so that they can then give it to their future customers, the controllers, to show that they're in compliance. So in addition to that, all processors are required to only process personal data on instruction from the controller and inform the controller if it believes that that instruction actually infringes on the GDPR. So basically, a processor can't mine personal data that's been entrusted to them for any purpose that's not outlined by the data controller. They have to obtain written permission from the controller before engaging any subcontractors, and they have to assume full liability if that subcontractor fails to comply with the GDPR standards. Upon request, the processor has to delete and return all personal data to the controller at the end of the service contract. They have to also enable and contribute to compliance audits conducted by the controller or a representative of the controller. They have to take reasonable steps to secure the data. This can be such as like encrypting it or giving it some kind of stability or uptime, backup, disaster recovery, regular security testing. They have to notify the controllers without undue delay upon learning of any data breaches, and they have to restrict personal data transfers to a third country if legal safeguards are obtained. So that one's kind of a big one. They can't use a processor that's not following the EU's program. Basically, is what that says. So a processor is also required to keep a record of their data processing activities if there's any of these certain criteria. So if it's a company with 250 or more employees, if the data is likely to result in some kind of risk or right of freedom of the data subject, if the processor is in the business of processing data more than occasionally, or if the process is like special categories of data, so something like criminal convictions, things like that are of more sensitive nature, they have to be, they need a data protection officer elected or employed to kind of govern those things if it's sensitive data. So how do you comply with this if your company, I work mostly with cryptocurrency companies in the United States. And so what that means for them is if they're collecting emails from their clients, like if they're an ICO and they're doing a whitelist or any kind of cookies, anything that they're collecting, they have to update their privacy policy to comply with this new standard. So I did write a blog. It's linked on this YouTube video, and that kind of outlines what has to go in the privacy policy. You can also see a lot of templates. I know I, for one, got quite a few emails today with new privacy policies. So take a look through those. They're supposed to be easy to read. And also, you can feel free to hire an attorney to help with this too. So what you have to do in your privacy policy is provide users with thorough information about how their data is actually being processed, and it has to be communicated. I like this law. It says right in the law that this policy has to be concise, transparent, intelligible, easily accessible, in clear and plain language, and free of charge to the user. So they don't want some long, complicated document full of legalese that they know no one's going to read or take the time to, even go through it. It has to be non-friendly, non-technical, and user-friendly. And there's 8 rights of the consumer or the user that have to be discussed in the privacy policy. It's the right to be informed, the right to access, the right to correction or rectification, the right to insure. So that's like, the right to erasure. So anything can be permanently deleted. You have the right for that. The right to restriction of processing, and the right to portability. So it has to be safe and controlled if the information is being transferred to some kind of processor. There's the right to object to processing. So you can say, without my explicit consent, you can't have my personal data. And then the last one is the right not to be subject to automated decision making. So they can demand that there's human intervention rather than having important decisions made via some kind of algorithm. And I think what that applies to mostly is like a credit score. If they say, okay, if you're under a certain credit score, you can't get a credit card, things like that. For banking is probably one area where they're using the algorithms. And then also for any kind of time where they're segregating people by gender or by race, you can request that they don't do that. So if it's like an employment company and they want 30% of the staff to be women, and then if you're clicking that you're a woman, you automatically get put in some pile. probably moving to the top. Well, maybe I guess if you're a man, you can say, I don't want to be part of that algorithm. So that's how it goes to play. And then additionally, your privacy policy, you wanted to include exactly what personal information you're collecting, why and how you're collecting it, how you're using it, how you secure it, any third parties that you're giving access to, if you're using cookies, how users can control any aspect of this, who the data controller is. So usually that's the company writing the privacy policy for the website, for like their own company. If you have a controller, you have to include if you are the controller, you have to put your mailing address as well as your email address. And if you have a data protection officer, you have to include their contact information as well. And email is sufficient. You have to inform your users whether you use the data to make the automated decisions. Like I said, credit scoring, profiling users, employment decisions. You have to put whether the providing the data is mandatory. So let the user know if they're required to give you that data, what happens if they don't give it. So for example, if they're trying to create an account and they won't provide their email address, maybe they can't create the account. You'd have to explicitly say that in your privacy policy. Whether you transfer the data internationally. So if your business does use one of these processors and they're in another country, you have to say that that's happening, and you have to say whether your data falls under the legal framework of the EU-US Privacy Shield. And you should also probably, or not just probably, you should include a copy of your corporate rules or the contractual provisions that have been outlined for that data privacy between you and the other company that you're using as the processor of your data. You have to put the legal basis for processing the data. So there's 6. These are outlined in the Article 6 of the GDPR, and it's basically the most common things of like what your legal basis is if you have consent by the client or by the user. If they give you consent, you have a legal basis to process their data. Secondly, it's if their processing is necessary for pursuing a legitimate interest. And a legitimate interest is a pretty broad one too. A lot of things can be included that are legitimate. Then the GDPR requires that you get consent for the data that you're collecting. So you have to actually make the user consent before they input the data. It can't just be a privacy policy that's stuck somewhere in the back of your web page that no one's going to look at and have them put all the information in and some small print somewhere saying you've agreed to our privacy policy. No, they have to actually see a link of the privacy policy, say they accept it, before they input their name or anything that you're collecting from them. And then there's a difference between affirmative and explicit consent that you need. So you take care of all of it if you just go to the explicit standard, which is having a box and a link to your privacy policy. But the difference is if it's their email address, their name, their financial information, that's where they need the affirmative consent. And that standard is that it has to be clear and unambiguous. But if you're collecting more sensitive data like someone's sexual orientation, any health data, any political, religious views, things like that, then it rises to that higher level of explicit consent. And so you also want to link your privacy policy anywhere that you're putting, that they have to put stuff in. And you can also have privacy notes. So next to where they put their email address in, just have a little thing next to it where they can hover over it and see their privacy policy. So hope that's helpful. Thank you. Bye.